Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Today I have with me Julia Perkins from the Varnum Group, and she is an attorney who works in the family law industry, and we are going to talk today about alternative ways to streamline your case. And this has mainly come up because the court system is so bogged down, right, Julia? And that's why we need to come up with alternatives.
Yeah, depending on the county,
Okay.
the courts are more bogged down than others, and some are just impossible to navigate.
So can you give me like the top 2-3 counties that are really, really backed up?
Well, the biggest county backed up is the biggest county in the state, and also one of the biggest counties in the country, which is Wayne County. And the lack of resources. I would say other courts are hit and miss. Oakland County is as efficient as ever. And so when clients come to you and you ask where they live, you kind of have to explain to them. It changes the landscape of their case, right? Because you're not going to be able to get into you're not going to be able to file a motion and be heard in Wayne County for 2 to 3 months. And that can be debilitating to a case. You may in Oakland, you will in Oakland, but you still have, you still have hurdles and obstacles and lines that you have to go through in order to get your case progressing. And, that takes time too, obviously.
Right. So give me some alternatives to speed things along.
Well, and all of this is dependent upon who your opposing counsel is and whether or not they're willing to entertain alternative, what is standard alternative dispute resolution.
That's a good point. If someone files for divorce, then are you kind of stuck to one method?
You're not stuck to one method, not at all. And sometimes you have to file for divorce in order to get a lawyer appearing on the other side. Sometimes clients have discussions ahead of time and they say, look, I want a divorce, I'm going to file. And then they both start looking for attorneys, or one has an attorney, the other one starts looking for one. But in most cases, somebody doesn't get an attorney until a complaint is filed against them, and they now need to respond and they don't know what to do.
Okay.
So you can file, you get an attorney on the other side. And if that attorney is someone who is someone, typically we know the attorneys. Sometimes we don't, but look, after 30 years, you kind of know everybody. Who will do some different early mediation, or, hey, let's have a 4-way meeting. Let's talk about what the issues are. We will engage you if we have issues related to, the mortgage process and how do we need to construct the judgment in that case. But, look, if we're in Wayne County, we need to mediate sooner rather than later. And if we have issues related to parenting time in the interim, or support in the interim, or status quo issues in the interim, we need to get people involved that can hear us out quickly. Because again, as I said, it's not easy. I had a judge in Wayne County one time. We filed a motion to compel discovery. And he said, hey, look,
tell me what that means for everyone.
Oh, that's a good point. So we filed, we gave them interrogatories, which are basically just questions asking them about information on their assets. And in this particular case, it was a doctor and he had his own practice. So we needed information and documents. And he wasn't being that forthcoming. And so we filed a motion to compel, which means, hey, judge, tell him he's got to provide this a certain amount of time and give us our attorney fees for having to come here. And we filed our standard motion to compel, and it wasn't heard for 2 months. And when we met with this judge finally to argue the motion, he said, hey, look, in the future with me, period, on any case, file your motions to compel discovery as an emergency. Because it took 2 months to get heard by the judge. The judge ordered him to produce the information, but he required, he gives him a certain amount of time to pull it together and provide it, even though he should have provided it 2.5 months earlier.
And then could he be moving money and doing all kinds of things in the meantime?
Oh, sure. He could be doing that. The other problem with all of this was, or is, and I'm sure you've heard this with other attorneys in your cases, the courts have to resolve a divorce case in Michigan within a year. And resolving it means they've either agreed on a judgment of divorce, a consent judgment of divorce, or you started trial. And so when we delay receiving information for 2 months, and then he gives them another month to produce, and we have experts trying to value the business who are also very busy people, we're coming up on time standards and we're not prepared. So in those instances, it might be good to hire, to retain somebody to be the discovery master, which means just, hey, this person rules on the discovery. We don't have to go to the judge. So this person can resolve these issues within a week. So that's arbitration, basically. Okay.
So you still are obviously needing the information and people have to agree to arbitrate, right?
Sure. They absolutely do. I mean, they can just say, nope, I'm not going to do it. I'm going to bog you down. I'm going to delay things. And, that becomes very problematic in a county where you can't get in quickly.
And no extension on the year. I mean, obviously, if it takes more than a year, it takes more than a year, but everybody gets all these bad marks, right?
Well, the judge gets the bad marks. The attorneys could care less.
Okay.
The clients want their case resolved. And, that's fair. Once you decide you want a divorce, you've engaged an attorney to do that for you. You wanted it done, a month ago.
Right.
So when you tell a client this might take a year, and you might, you might start a trial at, 11 and a half months in, but once they start the trial, they're not pinged by the Supreme Court. They just need to continue the trial. And so, you may not have a resolution for, another 6 months, because trials take a long time in court. In almost every jurisdiction, courts are bogged down with hearings, and they have busy schedules just like attorneys do. And so when you start a trial, you might have a trial for a day and you need 4 more days, and they come one a month.
Oh goodness.
Yeah. And that's in a lot of places. And that just depends on the judge's docket and what they have free up and what they don't have free up. So, that's something to consider too.
And what are, and I don't know if this is even a good question, but what are the penalties to the judge if these cases take longer than a year? Or what's the consequence to that?
I haven't met a judge who doesn't care about their time standards. There's not a penalty in the sense of you have to pay in money or anything like that. But they're elected officials. And so if anybody is looking at their efficiency rating or, something like that, the Supreme Court has, a list of how many cases this particular judge has over time standards, and no judge wants that. and you can't blame them. And
Right.
I don't blame them. It's you know, the family law attorneys who I speak to, we all think the time standards are stupid. I mean, there are some cases with kids and W-2 employees for both parents, and their assets are pretty straightforward, and you can get them taken care of in 4 to 6 months. But there are some people without kids, and you have a couple of businesses, and you have an independent contractor consultant person, and you're trying to determine what income is, and you're trying to determine the value of these assets. You need time to do that.
Right. And people aren't always forthright. What's funny is, so for mortgages, we have this rule that we have to get mortgage approval within 30 days of somebody making mortgage application, or we're out of compliance and we have all these issues. And here somebody wants the mortgage, and sometimes we have a hard time getting all the documents and getting the tax returns and having all the stuff, and they want us to succeed. So I
Right.
can only imagine what it's like in your shoes when they don't want, the other party, you're relying on someone who doesn't really want you to succeed or try to be sneaky or what have you. But I know if I have someone who owns a bunch of rental property and they have a bunch of different businesses, and then they're not reporting the income that they said they were reporting, or they haven't filed tax returns, or they owe all this money, it takes us a lot of time to maneuver through all that.
Exactly. So. And we also have issues with respect to parenting time motions in these counties that aren't that efficient in getting you in. And if you're in a case where you represent somebody who has had a complaint filed against them for custody and parenting time, let's say, and they're separated, and your client isn't getting parenting time, and mother is not, it's usually the child is with the mother, and the mother is not being very cooperative with respect to parenting time, you file a motion for parenting time, you might be waiting 2 months to be heard. And in most counties, you go to the friend of the court first, and then you have a certain period of time to object to whatever the friend of the court recommends. And so you could be going 2 months without seeing your child, 2 to 3 months without seeing your child, if the parent's being uncooperative.
Right. That's so.
And let's face it, it's human nature once you
Right.
get into litigation. So it's been difficult, and there's more litigation, and there's less settling. And this is a survey, informal survey I've done among my colleagues. We all believe that it's been harder to settle cases, especially like mediating on Zoom, or going to court on Zoom, or having trials on Zoom, because people are in the comfort of their own home.
Right.
And they don't have to put on a full suit. They don't have to schlep down to Detroit. They don't have to find parking for $30, $40 a day. They don't have to sit in an uncomfortable courtroom, in an uncomfortable courthouse for
Nervous,
8 to 9 hours. And so they're not invested.
Right.
I've had judges and referees.
It makes sense.
Yeah.
Even when you're sitting there and you see that whole formal setting, it's a little scary, right?
It's intimidating. Yeah.
It's intimidating. And you're right that I could see where it gets a little harder, because you don't have, and then you don't know who's around them giving them advice, or, listening, or.
Yeah. Yeah. And you can tell, because people look this way and they look that way, and then they'll nod. They'll do that.
Do you think going back to court will be a thing, and then it'll get a little more efficient because people won't want to take time off work and all that other stuff? Or you think Zoom is here to stay?
I think Zoom in a modified way is here to stay. there are certain judges who would like to be, they do in-person court, and now it's kind of at their discretion. I think there's 3 family law judges in Oakland County who are in person largely. There's a couple in Wayne. But I think I think court as we knew it pre-COVID will never happen again. I won't likely have to go in person for a status conference in most courtrooms. It's just inefficient, and it's so much easier to do it on Zoom, and it's cost effective for the client, and it's a status conference. Nobody really cares. Hey, this is what's going on, right?
Right.
But I'd like to see motions and trials and evidentiary hearings be in person. It's surprising how much you get settled when even lawyers who have to schlep down to court, and you're sitting in court, you're waiting for 2 hours, and your opposing counsel's there, and you finally just get up and say, "You want to go talk in the hallway?" And I can't tell you how many times I've resolved a motion that way. We can't do that on Zoom. We just don't do
I
it.
can see where that's lost. Plus, you're working, right? So you're working till the very last second. You're done with Zoom. You're back to doing your
Yep.
email. So you don't have that aggravating, this is wasting my whole day. I have so much to do.
Yep.
Yeah, that's tough. And it's too bad, like the things that they matter, but they don't matter, the wasting someone's time and the being formal and the driving, like that's the significant difference.
Yeah, having to take a full day off of work as opposed to like a few hours off of work.
Or
That's a
worried if
huge
you're not
thing.
going to get home in time to pick your kids up from the bus stop, or
Yeah,
right. All those incidentals become really important.
they are. They're just a huge hassle. And so you have to put everything in perspective. And we're not putting things in perspective on Zoom. I can take care of this, and then I can, and while I'm waiting, I can be working. I'm actively working, checking my email, and that's what my clients do. They just wait to get pulled into the courtroom. So until they do, they're not really that inconvenienced.
Right.
So it does make it a lot harder. I am more open to in-person evidentiary hearings, trials, mediations. Let's face it, there's no reason for us to be separated anymore.
Right. Right. Except we're all lazy now.
We are.
Right.
We are. And the other thing too is back before Zoom, back before COVID, everybody had to appear for trial in person. There's court rules on that, unless they have an extenuating circumstance. They're not appearing via Zoom to testify. So now you have a witness in California that can just Zoom in, as opposed to, are you going to really have that person from California fly out? Are you going to pay for that person from California fly out here and testify in a Michigan courtroom? And by the way, we don't even know if you're going to get called that day. It was a big deal to take a witness out of order. They're in from California. They're going to go back tonight, Your Honor. I'd like to take them out of order. And then, the court looks at opposing counsel. And what are you going to say? No.
Right.
But technically they don't have to agree to that. So it's reduced. It's reduced the cost of litigation. I mean, litigation is still prohibitively expensive, and I don't recommend it, but trial or evidentiary hearings, but it's reduced the cost for sure, and convenience.
Right. So what people should do then is either file for divorce or not file for divorce, but try to kind of work on the back end, you're saying, to try to get things done.
Yeah. So there's collaborative mediation where they start prior to filing. They do engage attorneys, they engage experts. One would be like you on the mortgage side. There'd be maybe experts related to finances and stuff like that. And they really try to work towards a resolution before they start going down the court realm. And it's less antagonistic. But there's also just regular mediation, and hey, let's get into mediation sooner rather than later. Let's issue spot. Let's see what our problems are. With two really good attorneys that can get along and talk to one another, sometimes you don't even need to employ a mediator. You might need an expert because of, they might own a business, agree on a mutual expert for the business, get appraisers involved, for the house or whatever. So there's different ways to skin a cat. And even in like cases where people are having issues with respect to children, get the therapist involved. And if you're arguing about parenting time, pick an arbitrator. Pick somebody. Even though you have to pay an arbitrator, it's cheaper than having to go to court because court is less efficient. The courts have other things to do that day. An arbitrator will block off a number of hours dedicated to you. Whereas a judge, they may have a few things on their docket in the morning, a few things on the docket in the afternoon, and then an emergency show cause on something. Who knows? And so you spend a lot of your time with judges waiting for them to be available. And it's not the judge's fault. It's just the nature of what they do, and it's the nature of our judicial system. So there's a number of ways to skin the cat. What's that?
It's like the doctor's office waiting room.
Oh gosh. Yeah,
if you do these other alternatives, and then let me just make sure that I'm understanding this. So then if you normally are waiting 2 months before you, I guess, go in front of a judge or something comes up with the judge, and now you go in front of the judge, do you say, oh, well, we already worked out everything, so we're done? And then you don't have
Well, there's a 2-month waiting period from the date you file until the date you enter your judgment. So you have a 2-month waiting period at the time you file. Now, if you do something like collaborative mediation where you get a resolution before you file, you just, you file and you contact the court's chambers, even in Wayne County, and say, hey, look, we're going to be putting a judgment on day 61. So can you give us a date? And so you get a date locked in, and then you can put the judgment on. When I say, if you file a motion in Wayne County, you won't be heard for a couple of months, that may be true. But if you call if you contact chambers and say, hey, we just have a quick pro-con to put on, which means just certain statements you have to make in order to get divorced, they'll fit you in because they want to clear up their docket as much as possible. And it doesn't take that long. It's not contested. You just go in, you do the statutory proofs, and you get done. So you don't have to wait that long once you have resolution.
That's good. They need like a pro-con.
Yeah. What's that?
You need like a pro-con day. Just line them all up.
Well, actually, some judges do have pro-con days where they just do pro-cons and they just knock them out.
Makes sense.
Yeah, absolutely.
I thank you for your time. It was informative to me, so I'm sure it'll be informative to everybody else.
Good.
How can people find you if anyone wants to get a hold of you?
So I'm at Varnum Law Firm I'm in the Novi office. My email is japerkins@varnumlaw.com. And if you go on the Varnum website, that's with a V. If you go on the Varnum website, it's easy to track us down. And that's where you can find me.
Perfect. Wonderful. Any last thoughts before we sign off?
My last thoughts would be, especially if you have children, and I don't care how much you hate your spouse, you have children together. And there's no principle in divorce, and there's no principle in litigation. And remember that, your kids are made up by the two of you. So when you bash on your spouse in front of your child, you're bashing on your child. And just try to keep everything in perspective. And as time goes on, it gets easier, and just try to be as civil as possible through the whole process.
That's great advice. That is great advice that a lot more people need to listen to. That's true.
Yeah.
Thank you for your time.
Well, thank you for having me again. I always enjoy it.
Yeah, it's fun.
I hope you enjoyed the podcast.
I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.